Hello people, good day. And I'm back with this time another political issue. This one is not just Jamaica, it's an international thing based on what going on in Jamaica. Thank you, Sir P. I could do some research. I don't know if you're a thing how personal your war is with Corrine, because you sound very angry. And the word the unitary state really make me go look. And this is where I come up with. Rights of Maroons in international human rights law. I find an article published December 2001, authored by Fergus McKay. It says, and we quote, "The vast majority of American states have ratified international human rights treaties that obligate them to respect the rights of individuals and certain groups. Some have also ratified International Labour Organization Conventions number 169, bracketed ILO 169, which deals exclusively with the rights of indigenous and tribal peoples. The rights of Maroon individuals and collectives are also protected under these instruments." The article provides an overview of the nature and content of those rights, with an emphasis on collective rights. Prior to turning to the substance of Maroon rights, I should point out that states have an obligation to give effect to ratify human rights treaties in their domestic law, as without those measures, international guarantees for the most part cannot be enforced or enjoyed by the intended beneficiaries. By virtue of both general principles of international law and specific provisions found in human rights treaties, states are obligated first to give effect without discrimination to human rights in their domestic law by constitutional amendment, adopting new legislation and/or modifying existing legislations, and second, to ensure that effective remedies are in place permitting rights to be enforced in domestic courts and other tribunals. While underlying rationale for protecting the collective rights while underlying rationale of protecting the collective rights of Maroons, the right to cultural integrity and the right to self-determination, the right to equality before the law and freedom from discrimination holds true in all cases. The manner in which the Maroons are classified under international law as minority, as tribal people, or as some other entity is important. Without engaging in a contentious discussions of how to classify Maroons, I will simply state that under international definitions, imperfect as they are, Maroons can be described as both minorities and as tribal peoples, the latter being most relevant in terms of collective rights. And while they are not indigenous people, Maroon enjoy largely the same rights as indigenous peoples under international law. The main distinction being that Maroons cannot claim aboriginality and the rights that attach to that status. For this reason, but also due to the lack of international jurisprudence on Maroon rights, I will make frequent reference here to indigenous people's rights. Maroon rights under international instruments. Minority rights are encapsulated in Article 27 of the UN International Covenant on Civil and Political Rights, ICCPR, which provides that in those states in which ethnic, religious, and linguistic minorities exist, Persons belonging to such minorities shall not be denied the right in community with the other members of the group to enjoy their own culture, to profess and practice their own religion, or to use their own language. These rights are held by individuals but exercised in a community with other members of the group, thereby providing some measure of collectivity. Similar language is found in Article 30 of the UN Conventions on the Rights of the Child. The points made here are therefore also relevant to the rights of Maroon children and by implication the larger community under that instrument. The UN Human Rights Committee has interpreted Article 27 to include the rights of persons in community with others to engage in economic and social activities which are part of the culture of the community which they belong. In reaching this conclusion, the HRC recognized indigenous people's subsistence and other traditional economic activities are an integral part of their culture, and that interference with these activities can be detrimental to their cultural integrity and survival. By implication, the land, resource base, and the surrounding environment also require protection if subsistence activities are to be safeguarded. So, Korea have a right to protect their compound. Right. The HRC further elaborated on its interpretation of Article 27 by stating in its 1994 General Recommendations, number 23, one or other aspect of the rights of individuals protected under Article 27, for example, to enjoy a particular culture, may consist in a way of life which is closely associated with authority and with its use of resources. This may particularly be true of numbers of indigenous communities constituting a minority with regard to the exercise of the cultural rights protected under Article 27. The committee observes that culture manifests itself in many forms, including a particular way of life associated with the use of land resources, specifically in the case of indigenous peoples. That right may include such traditional activities as fishing or hunting and the right to live in reserves protected by law. The enjoyment of these rights may require positive legal measures of protection and measures to ensure the effective participation of members of minority communities in decisions which affect them. The committee concludes that Article 27 relates to rights whose protection imposes specific obligation on state parties. The protection of these rights is directed to ensure the survival and continued development of the cultural, religious, and social identity of the minorities concerned, thus enriching the fabric of society as a whole. According to an HRC statement in July 2000, Article 27 requires that necessary steps be taken to restore and protect the titles and interests of indigenous persons in their native lands, and that securing continuation and sustainability of traditional form of economy of indigenous minorities, hunting, fishing, gathering, and protection of sites of religious or cultural significance for such minorities must be protected under Article 27, subsection 3. The basis for the protection of indigenous peoples' land and other rights under Article 27 is the right to enjoy culture, just as with the culture and economics of indigenous people. Those of the Maroons are fundamentally related to the ownership, use, and enjoyment of their lands and territories. These territories are inextricably intertwined with the social, ancestral, and spiritual relationships that govern Maroons' daily lives. Consequently, for Maroons to enjoy their culture, the same level of protection must be accorded. Under the Convention on the Elimination of All Forms of Racial Discrimination, assert, State parties are obligated to recognize and respect the rights to own property alone as well as in association with others, and the right to inherit both without discrimination. As with indigenous property, people's traditional Maroon lands tenure or property ownership is collective, with individual holding subsidiary usufruct rights, and such land tenure is different from property rights regime set out in state legal system. Failure to recognize and protect Maroon property and inheritance system and rights is a discriminatory and denies equal protection of the law. In its 1997 General Recommendation, the UN Committee of the Elimination of Racial Discrimination elaborated on state obligations and indigenous rights on assert. In particular, the committee called upon state parties to recognize and protect the rights of indigenous people to own, develop, control, and use their communal lands, territories, and resources, and where they have been deprived of their land and territories traditional owned by otherwise inhabit or use without their free and informed consent to take steps to return these lands and territories, and to ensure that members of indigenous peoples have equal rights in respect of effective participation in public life, and that no decision directly relating to the rights and interests are taken without their informed consent. Similar conclusions about indigenous peoples' rights have been reached under inter-American human rights instruments, specifically American Convention on Human Rights that apply equally to Maroons. First, it is well established in the inter-American system that indigenous peoples have been historically discriminated against and disadvantaged, and therefore that special measures and protections, affirmative actions, are required if they are to enjoy equal protection of the law and the full enjoyment of other human rights. These special measures include protection for indigenous languages, cultures, economies, ecosystems, and natural resource-based religious practices, and ancestral and other communal lands, and the establishment of an institution order that facilitate indigenous participation through their freely chosen representative, the Inter-American Commission of Human Rights, IACHR, characterize the proceedings as human rights also essential to the right to life of peoples. Protection of these rights then amounts to a broad prohibition of assimilation and ethnocide. The IACHR has dealt with indigenous rights in the context of environmental degradations and development activities on a number of occasions. Most recently, it found that Nicaragua had violated the rights to property, judicial protection, and due process of the law by granting logging concession on indigenous lands without taking steps to title and demarcate those lands, and to ensure that the affected communities could participate in decision making about those concessions. It looked extensively at environmental issues in its 1997 Ecuador report, which examined in detail the rights of indigenous people affected by oil drilling activities. It held that the right to life and a healthy environment are inseparable, that human rights issues arise when regulations protecting the environment are absent or not enforced, and that the right to access information and participation in decision making about environment and development related matters exists pursuant to rights set out in the American Convention. Addressing rights to land, territories, and resources, the IACHR found that indigenous people's property rights derive from their own forms of land tenure and traditional occupation and use. It has related these rights on a number of occasions to cultural integrity, thereby recognizing the fundamental connection between indigenous land tenure and resource security and the right to practice, develop, and transmit culture free from unwarranted interference. For instance, in 1997, the IACHR stated, for many indigenous cultures, continual utilization of traditional collective systems for the control and use of authority are essential to their survival as well as their individual and collective well-being. Control over the land refers to both its capacity for providing the resources which sustain life and to the geographical space necessary for the cultural and social reproduction of the group. It iterated that conclusion to its second report on the human rights situation in Peru, stating land for the indigenous people is a condition of individual security and liaison with the group. The recovery, recognition, demarcation, and registration of the lands represent essential rights for cultural survival and for maintaining the community's integrity. Finally, in 1997, the heads of state of the Caribbean community adopted the CARICOM, a charter of civil society which provides in Article 11 that the states recognize the contributions of the indigenous peoples to the development process and undertake to continue to protect their historical rights and respect the culture and way of life of these people. The charter applies to both Suriname and Jamaica, although its scope, in particular the question of whether Maroons are included in the category indigenous people, has yet to be articulated. Jamaica don't want it to be articulated in because they have plans. Alright. Territorial rights are interrelated with rights to autonomy and self-government, and both are related to Maroon rights guaranteed by their treaties with colonial authorities. The Organization of American States, OAS, and the United Nations in their respective draft declarations on the rights of indigenous people have recognized the right to autonomy and self-government on a mode of exercising the right to self-determination with existing states. The draft declarations also require respect for rights guaranteed under treaties between indigenous peoples and states. From the Maroon perspective, these historical treaties are sacred covenants by which they exchange a cessation of hostilities for political, territorial, and cultural autonomy. The treaties stand as a testament to the struggle of their most powerful ancestors and set immutable boundaries within which they can exist and prosper as free peoples. You can see Bill B of 1997 for that. Maroons can also be classified as tribal people. Tribal people enjoy essentially the same rights as indigenous people under the international law. ILO 69 defines tribal people as peoples in independent countries whose social, cultural, and economic conditions distinguish them from other sections of the national community, and whose status is regulated wholly or partially by their own customs or traditions or by special law or regulations. The IACHR uses the same language when describing non-indigenous tribal people. In Article 1 of its proposed American Declaration on the Rights of Indigenous People, thereby according Maroons the same rights as indigenous peoples under that instrument. This proposed declaration is presently under review by a working group of the OAS Committee on Judicial and Political Affairs prior to submission to the OAS General Assembly for adoption at some point in the future. Together with its predecessor, ILO number 107, ILO 169, is the only binding international treaty to deal exclusively with indigenous and tribal people's rights. It is based in the principle that indigenous and tribal peoples should enjoy as much control as possible over their own economic, social, and cultural development. It recognizes that indigenous and tribal people have the right to decide their own priorities for the process of development as it affects their lives, beliefs, institutional spiritual well-beings, and the lands they occupy as or otherwise use, and to exercise control to the extent possible over their own economic, social, and cultural development. It also contains 6 articles on indigenous and tribal land and resources rights, basing these rights on traditional occupation and use of the land and resources rather than on grants from the state, and a number of provisions relating to consultation and participation in decision making. To date, of the states in which Maroons live, only Ecuador and Colombia have ratified ILO 169. In both countries, ILO 169 provides the basis for constitutional and legislative changes recognizing some of the rights of Maroons in domestic law. Brazil is in the process of ratification, and Maroons in Suriname are lobbying the state with little response to ratify it. Human rights cases concerning Maroons. It is not surprising that international human rights laws and bodies have dealt with indigenous people's rights to a greater extent than Maroon rights. Given the strength and proactive nature of the international indigenous movement throughout the past 30 years, indigenous peoples have actively engaged their state, the UN and the OAS, the World Bank and others to account for their rights, and have sought enforcement of their rights through international mechanisms such as the HRC and IACHR. By comparison, and with few exceptions, Maroon have only recently begun to assert their rights at the domestic level and have not sought redress at the international level. While the IACHR has addressed Maroon rights in its country report on Colombia 1999, Ecuador 1997, Suriname 1983 and 85, it is only Suriname Maroons who have sought enforcement of their rights in the IACHR. Even then, only one case filed in October 2000 deals directly with rights to ancestral lands and resources, treaty rights, rights to cultural integrity, and rights to participate in decision making affecting Maroon communities. The best known case is Halo Boto et al., decided by the Inter-American Courts of Human Rights in 1993, in which Suriname was held responsible for the extrajudicial killing of 7 Saramacca Maroons during the Civil War of 1986 to 1992. Padilla 1995, Price 1995. In determining reparations, the court explicitly took account of Maroon customs and laws. Example, the polygamy, to set the amount of compensation due the victim's dependents. It refused, however, to require compensation for violations of Maroon territorial and treaty rights, effectively declaring the Samarkand Treaty of 1762 as null and void. A second case dealt with the massacre of more than 50 Niduka women, children, and elderly persons by the Surinamese army at the village of Moiwana in 1986. This case was declared admissible by the IACHR in March 2000. A decision is presently pending on the merits and possible adjudication pursuant to binding jurisdictions of the Inter-American Court. A third, most recent case was filed by 12 Saramacca leaders, captains, on behalf of their respective matrilineal clans and the Association of Saramacca Authorities. A body representing the majority of the Upper Suriname River Saramacca captains. The petition alleges that Suriname had been violating the rights of Saramacca's matrilineal clans, individuals, and the Saramacca people as a whole to property, to participate in decision affecting them, to cultural integrity, to judicial protection, and to other rights guaranteed under international instruments ratified by Suriname, such as the right to self-determination. The case was filed with the IACHR directly due to the absence of effective remedies in Surinamese laws pertaining to Maroon, land, and other rights. It is based on Suriname's failure to recognize Saramacca's territorial and treaty rights and its active violation of those rights by grants of logging and mining concessions in Saramacca territory. The petitioners seek IACHR support to establish procedures in domestic law that will recognize Maroon territorial rights and provide for the demarcation of their communal lands for immediate suspension of all logging and mining activities in their territory, and for reparations for past violations as with the marijuana case. Suriname has thus far failed to respond in any way to the IACHR's request for information about the allegations made in the petition. The basis for asserting and protecting Maroons' rights is firmly entrenched in international human rights law. But as with indigenous people, much work is required to ensure that states implement and respect these rights at the domestic level. While Colombia, Ecuador, and Brazil have made significant progress, on paper at least, Suriname, French Guiana, and Jamaica trail behind. And the situation on the ground in Colombia, Ecuador, and Brazil demonstrates that legal guarantees are not enough to ensure cultural integrity and survival. Guarantees must be backed up with effective and proactive enforcement measures. In this respect, it is crucially important that Maroons themselves assert and defend their rights and interests. Let's say this again. Guarantees must be backed up with effective and proactive enforcement measures. In this respect, it is crucially important that Maroons themselves assert and defend their rights and interests. In Suriname, where legal guarantees are entirely absent, the situation is almost dire. There, Maroons are experiencing an onslaught of mining and logging operations that is substantially undermining their ability to sustain themselves and causing massive environmental degradation and severe social and health problems. Matawai Maroons, for instance, have recently been forced to import water due to river pollution caused by mining. Conservation activities, however laudable in principle, are also cause for concern as they have expropriated Maroon lands and curtailed Maroon subsistence rights. Whether the latest case filed by the Saramacca with the IACHR will change this situation remains to be seen. Needless to say, other Maroon peoples are looking on with great interest. So with this Jamaica thing, a compound town, the Maroon lands round us away, over the past few years, we have come to the forefront of things of foreign investors buy up lands and curtail piece from the outskirts, from the northern and come in. Right. These people, them now together enough to maintain that and keep out the people them. Cause these people, they must scout you while they must scout your property. They must scout which part of it while them sneak in for some more. Are your weak side. And now them have a new chief. The other day they may have one bank down there. I don't think the bank exists no more. All kind of little things are going. Some little financial dollar sign base things are happening in them areas where we now hear about. So something big look like out to come out of this up. And the powers that be don't want us to know. And it look like this guy a Curry come step in for something and be mashing some other people's cars. I think this bank bank when me not hear about, I think him come cast that bank, whatever it is. I think it shut down or something. Don't know how I go on with that, but I'll check some more, I'll search some more upon that, see if I find more. Where I go on with that thing, man. I don't know. I hear Syrupy I go hard upon this one, yeah. I don't know if it's a case of I don't like the messenger. So the message, we dump the message because we don't like the messenger. Enough of these places. If you tell some Jamaicans that Jamaicans used to rule the world, say black people used to rule the world, them tells you a lie. But 2,000 years ago, black people rule the world. $2,000 years or even less than so long. But we now don't want to hear that. Because we start rule. We bring down ourselves to give me it easy. The easy pickings are what we like nowadays. The Maroon, them and the Haitians. Jamaicans are like Haitians. Haitians fight for them freedom. Jamaicans are like Maroons. Maroons fight for them freedom. The only thing would I ask now, are these people really sovereign? If you're sovereign, you can't use for them birth certificate. You can't be sovereign and then own you. Because if you apply for your birth certificate under for them state, if you use for them name, you use a driver's license, any one of them government thing there with the government kind of financial bonds mark round the edge of it, you're obligated to them, you're not sovereign. You have to buy back your sovereignty from them. That's why you see police can quickly lock up a man because he will away. No, we're not sovereign. We are just a person. We're no man. We're not men, we are sovereign. We are crown property. So possibly these people, why Curry might appear for, see when name Curry might appear for him, might appear for him that and become a sovereign person. How much we can copyright with name and use, if anybody use with name, any farmer with name, we have to get paid. Well, Sir P, you really send me go do a research. Some other things happen. Indigenous people worldwide. Nation states. Anyway, people, I'm gonna leave this nation states part tight and unitary state, cause them were the kind of get the thing kicking off, in the political system. But and the political system was really the intent of the search. And the aggression, the way the aggression was where made me decide to go look upon the Maroon part of the thing. If some laws, some recent laws come out about Maroon and land. So that I go look for rights of Maroon. And people can go look on for further information, you can go look for the Declaration on the Rights of Indigenous Peoples. And say indigenous peoples are not considered political nation states and do not have access to international law protection through international courts of justice. So, on that part there, them little thing they help add up. Is the foreign minister them with their Jamaica the opportunity to do with them feel like with the people them. Our Jamaican people that the average Jamaican him not gonna look so far internationally as the way people are say outside, Not too much. I'm not like the person I bring the message. Call me, I bring this, I know. Enough for who know me personally. I'm out me stress for talk. See the information, man. Look up these things. I'm there for the whole we find it.